Welcome to the Mogan Rubin blog in this audio post for September 24th, 2020. I'm Tom Hagee, Editor-in-Chief. Today we present an article by Mogan Rubin partner Jennifer Oliver on the end of a decades-old rule that governed the practices of movie studios and movie theaters. What was once considered an antitrust law violation, and how technology, among other things, changed the motion picture landscape. And now, here is our narrator, Nancy Forbes.
Anti-M and Antitrust. Ending ages-old ban, movie studios may distribute films and own theaters, by Jennifer M. Oliver. At the end of the beloved 1939 film, The Wizard of Oz, Dorothy famously says to her Auntie M, "There's no place like home." It's one of the best-known quotes from one of the happiest of happy endings to ever come to movie theaters. But there was much more going on behind the scenes than just Munchkin Land. The year before the film was released, movie studios and the federal government clashed when the government enjoined certain of the studio's most lucrative distribution and licensing practices. The government pursued 5 large companies which produced films, distributed films, and played their films in their own theaters. The companies were Paramount Pictures, Loews, RKO, Warner Brothers, and the 20th Century Fox. In a case that would be led by Tom C. Clark, who served in President Roosevelt's Department of Justice and then as President Truman's Attorney General in 1945, the government charged that the vertical combination of producing, distributing, and exhibiting movies violated Sections 1 and 2 of the Sherman Antitrust Act. Each company had entered into various contracts with the theaters which unreasonably restrained and monopolized trade, the government argued. In an unhappy ending for the studios, their litigation over these practices culminated in a 1948 decision against them written by Associate Supreme Court Justice William O. Douglas. He wrote in United States v. Paramount that the aim of the conspiracy was exclusionary. It was designed to strengthen the studio's hold on the exhibition field. In other words, Justice Douglas held the conspiracy had monopoly in exhibition as one of its goals. After this decision, the Antitrust Division and the studios entered into a set of consent decrees known as the Paramount Decrees. These agreements substantially altered the way studios conducted business. They were required to separate their distribution operations from their theatrical exhibition operation and sell off their theaters. They also agreed to end a number of other practices, including block booking, which is bundling the multiple films into one theater license, circuit dealing, when they would enter into one license that covered all theaters in a theater circuit, resale price maintenance, which is setting minimum prices on movie tickets, and granting overbroad clearances or exclusive film licenses for specific geographic areas. On August 7, 2020, Judge Annalisa Torres of New York's Southern District said times have changed. The judge held that the conspiracy and practices that existed decades ago have since faded to black. In the 1930s and 1940s, requiring a group of theaters to consecutively show all of one company's movies tied them up for weeks or months, thus foreclosing independent distributors from the first-run theaters they needed to successfully launch and distribute their films, the judge wrote. While some areas today may have a single one-screen theater, most have multiple theaters with multiple screens and can show movies from different distributors all at once, Judge Torres noted. There are also many other movie distribution platforms, she wrote, like television, the internet, and DVDs, that did not exist in the 1930s and 40s. Given these significant changes in the market, there is less danger that a block booking license agreement would create a barrier to entry that would foreclose independent movie distributors from sufficient access to the market, according to the judge. Market changes have also limited any dangers posed by the practice of circuit dealing, she wrote. The Department of Justice moved to terminate the Paramount decrees immediately, but with a 2-year sunset period for the block booking and circuit dealing provisions to give theaters time to transition. The judge held that the Antitrust Division offered a reasonable and persuasive explanation for why terminating the Paramount decrees would serve the public interest in free and unfettered competition. Clearly, the business of making and distributing movies has changed in the 80 years since the consent decrees were first entered. And some argue that the decrees could even pose a restraint on innovation. But smaller independent theaters and the theater chains are right to be concerned about what might transpire now that the decrees are lifted. For example, block booking may not hurt the large, well-known theater chains with plenty of screens, but if those practices reemerge, small theaters could find it impossible to get big movies, and small distributors could lose access to big chains. At the end of another beloved film, 1946, It's a Wonderful Life, Clarence the Angel tells actor Jimmy Stewart's despondent George Bailey, "You've been given a great gift, George. A chance to see what the world would be like without you." Now, given the ending of the sequel to the Paramount decrees, we will see what the world will be like without them.
That brings us to the end of this Mogan Rubin audio post. It was written by partner Jennifer Oliver, an award-winning attorney who specializes in antitrust law, complex business disputes, and investment litigation. Jennifer is also a certified information privacy professional. Mogan Rubin, LLP. Antitrust and competition specialization. Deep litigation experience. Sophisticated economic and business acumen. Relentless advocacy. For more information about the firm, visit moganrubin.com, and don't forget to sign up for the blog digest to get the attorney's insights delivered to your inbox.